recording. Good afternoon, everyone, and welcome to today's Multi-State ISAC and Elections Infrastructure ISAC National Webinar, which focuses on the General Data Protection Regulation, or GDPR. We have a great turnout for today's event with over 1,000 registrants signed up for this webinar. As some background for today's webinar, this presentation will provide a general overview of the General Data Protection Regulation that is going into effect on May 25th, 2018. This webinar will provide some insight as to why all SLTT, or state, local, tribal, and territorial entities, should be concerned about compliance with the regulation. Examples that SLTTs may not have considered will be explored and discussed. This presentation will also provide an overview of the steps to take in determining the need for compliance, as well as a general review of applying the risk management process to assist with compliance. Information on a quick assessment tool will also be provided. Our speaker today is Lynn Pizzini, who is the Director of Cybersecurity for Cirium Networks. Lynn is responsible for the management, oversight, and strategic vision to advise and lead clients through the cybersecurity environment and threat landscape. This includes the development and facilitation of cybersecurity programs to guide clients in reducing their cybersecurity risk. Her responsibilities also include cybersecurity assessments, vulnerability management, governance, and compliance. Prior to Lynn's work at Cirium Networks, she was the Deputy Chief Information Officer and Chief Information Security Officer for the state of Montana. She has over 20 years of experience in the cybersecurity industry and has been involved with many security and privacy-related initiatives in both the public and private sectors. With that, Lynn, thank you so much for participating on today's MS-ISAC EI-ISAC National Webinar. We'll turn things over to you now.
Thank you, and hello, everyone. And I just wanted to say thank you for MS-ISAC for hosting this event today, and I'm so glad that we have a great turnout. You know, this is an issue that has been highlighted a lot in the news, and I hope today will be very helpful for you as we go through just some things that we may not, as government entities, consider, as well as others that might be on the phone today. And I hope that the information that's provided is helpful. And so let's go ahead and get started here. Today we will be discussing several things. I do want to provide an overall description of GDPR, some examples, and just get into some of the roles and responsibilities, rights of individuals, and what you should do as an organization, as well as a brief checklist and how we compare this with our other risk management projects. And I do want to just begin by saying GDPR is a pretty complicated regulation. The documentation for it is over 200 pages long. Just, you know, think about NIST. It's comparable, and I also think about it as being like HIPAA on steroids. So today's presentation is going to be just a general overview of what it entails, not down into specifics. That can take days, and in fact, I've been to a seminar that was a couple of days that was an overview, as well as I've been doing a lot of online training. So just to get the specifics of it takes quite a bit. And so today I hope I can narrow those down to help you at least understand it, and maybe how you might need to apply it in your organization. So just a brief overview here. GDPR, of course, is the General Data Protection Regulation. And prior to 2016, the European Union had privacy regulations in place, and the members of the European Union had adopted that regulation, but they had also adopted some additional regulations in individual countries, and so it was very difficult to know what applied to what country. And so they decided to update the privacy regulation, and that's when they came up with the GDPR, which was adopted in 2016. And they have provided a 2-year implementation time frame for everyone, and so that's why it becomes effective and enforceable on May 25th, 2018, which is not too far away. So just briefly, it enhances personal privacy rights of European citizens. It increases duty for protecting data, and this will help us if we're security professionals. You'll see the light here that will help you with if you have to implement some compliance with GDPR. It also has mandatory breach reporting, and then it has significant penalties if you're not in compliance and found to be out of compliance. So that's just a general brief overview. And then also just a lot of people think that this really doesn't apply to them because they don't do business in Europe, or they don't have any ties to Europe whatsoever, but it might surprise you, the ties that you have. And this rule does apply to all companies, government agencies, nonprofits, and any other organization that offers goods and services to people that are European citizens. It is applicable to any organization of any size. So it really has come down to personal data of people from the European Union. And that data can reside in many forms, databases. It can be feedback information. It can be email content. It can be a photo. IP address is included here. And also things like cookies, file shares, things of that nature. So it is information related to a European person, like a name, an ID number, location data, online identifier, or one or more factors that are specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that person. Wow, it covers a lot of things. I mean, it basically covers everything you could possibly think of that is personal about a person. And so if you collect any of that data, it may relate to you. So let's just talk about, okay, how does this relate to me? Why do I need to be concerned? And here's some examples that you may not have considered, especially as a government entity. So I have some questions here that you can ask yourself. You know, do you collect name and email address of people on a website for things? And I think about, from a government perspective, sometimes we will provide tourism information or just general information about living in our state or county or city, or attending our university or school, and that is open to pretty much anyone to be able to put their information in, and so that would include people from the EU. Another question you can ask is, do you advertise job openings on a website, and can anybody apply for those jobs, including someone that lives currently in the European Union? Could you have a former employee that's moving away, and you still have their data and maintain their data in a database, and now they've moved over to the European Union and then even possibly become a citizen over there, and if that's the case, you still have their data and GDPR could apply to you. Do you maintain any type of licensing information for non-U.S. citizens who may have a work visa that work for you, such as, for example, I know the state of Montana has licensing of hairstylists and dental hygienists and doctors, you know, a different licensing like that, and you could possibly have someone from the European Union that is here in the U.S. working on a work visa. that you have information in some of your databases, and GDPR could apply to you. How about hunting licenses for EU citizens? Do you allow people to come from the European Union to come in, hunt in your state, and then they have to have a license to do that, and you have their information in your databases somewhere? And then, of course, I mentioned it earlier, but IP addresses, if you maintain that information in a log, that could be information that is subject to this. So really some things that I think a lot of people haven't considered unless you really dig down and look at the regulation. Now, one thing that I want to just lay out on the table here, because I've had a lot of conversations with a lot of people over the last several weeks about GDPR and if indeed we should be compliant with it. And I've had some very great discussions and debates with several people. I just want to say a shout out to my friend from the city of Spokane, Dan. I enjoyed our conversation a couple weeks ago about GDPR. He brought up some very good points about, you know, we live in the U.S., this is a European regulation. Why do we need to be compliant with it? And that's a good question, and it's yet to be determined. But I also ask, you know, we have a lot of laws in the U.S. that pertain especially to the internet and things that are going on in the digital environment, and we apply those laws to people outside of the U.S. And so, but then again, I talked with a friend of mine last week. He mentioned the Boston Tea Party, and that's why this slide is up here. And I thought, yeah, you know, that's why we became the country that we are, because we did not want to be under other regulations without representation. And so it is a debate, and I'm not here to say whether or not you are supposed to be in compliance. That is up to you as an organization, and you have to look at the data that you have and look at the regulation and decide, is this something that I need to be in compliance with? I will say this, and all I have to do is mention Facebook, and everybody goes, yeah, you know, the U.S. Congress has been taking a very strong look about privacy and privacy law in the United States. And I believe that, you know, it's just a matter of time before we actually have that privacy law that's incorporated into our laws here in the U.S. And so this is just a precursor, I think, to what is to come. And so it's something that we all need to consider. But again, it's really yet to be determined about how they're going to enforce the law. There's a lot of speculation about whether or not they're going to come after a specific people or organizations to make them examples. There's all kinds of speculation from that perspective. But again, we just have to look at it from each organizational perspective and make that determination. And so today, I hope that at least you'll understand about the regulation and how you can apply it to see if you need to be in compliance with it. So let's go on and let's just talk just a minute about the 3 roles that are covered under this regulation. First of all, you have your data subject, of course, and that would be your EU citizen that has data that they may have given you or that you have registered. And then there's the data controller, and that person or that organization is the one that determines the purpose of how that information is going to be processed, what's going to be done with that data. And then you have the data processor, and I like to give the example of like Amazon, AWS, or Microsoft's cloud environment, those are actually data processors, because a lot of us as organizations have information out in the cloud, and they are our data processors, and they have to be in compliance with this regulation, because if an organization uses them to store data from European citizens, and they must have to be in compliance as well. So those are the 3 different roles that people have under the regulation. And so let's now just talk about some of the principles involved with GDPR. So the principles really cover how we're going to be accountable about data. It tells us that we must process our data lawfully, fairly, and in a transparent manner. We must, again, I talked earlier about this, it seems like HIPAA on steroids. It's very similar to some of the HIPAA requirements from a privacy perspective. We are only supposed to maintain the data as long as we need it. We should make sure that we process it in an appropriate manner, and we have security in place. So yay for security, because this, I believe, helps the security arena, because it reinforces the need for security. So these are just a few of the principles, and so let's just dig just a little bit deeper into the lawful processing, because if you have this data, then you must do it lawfully, and it has to meet one of these 6 criteria or 6 conditions. And most often organizations look at the consent condition, which is the first bulleted item here, and that indicates that you must have the consent of the individual to maintain their data. And we're going to cover that a little more, but it is an opt-in, not an opt-out type of consent. Other areas that you may choose to have the data and maintain it for lawful processing is you might have a contract in place that you have a contractual obligation to have the data or process it, or a legal obligation, especially as government entities. There's a lot of legal requirements where we have to have data. And for example, hunting licenses. We have laws that say we need to have contact information on whoever has a hunting license. And so that's a legal obligation. Another area or condition that you may consider is having information for the vital interests of the person. You may need to maintain information to help an individual. Next could be public interest. I think of the Center of Disease Controls in this perspective. You may, at your Department of Health, maintain information on any types of diseases that have to be tracked, and someone may be visiting your state, your county, and they bring a disease, and then you have to have that information about them, and if they're a EU citizen, it could be susceptible to this law. So again, just need to know what your data is. And then, of course, processing for purposes of legitimate interests. A lot of organizations use that one as well and say you maintain information because that's your business is to maintain information. That's a legitimate interest. So you do have to, if you are keeping this data, you need to have it under one of these conditions. And so let's just talk a minute about consent. As I indicated earlier, it is like an opt-in, not an opt-out type of thing, and you need to be able to demonstrate where you've requested that opt-in, so that consent was given by the person that gave the information. It must be clear, in other words, understandable. Communication needs to be understandable. They need to be able to withdraw it and take it away, and ticking a box or choosing appropriate technical settings is still a valid way to collect that information, and a lot of us have seen that before. You know, you check a box that says I opt in, and so that is still a valid way to record consent. So let's just talk just a second about special categories, because there is a need for exceptions for special categories, and those are listed here on this slide. If you're collecting information about race, ethnic origin, religion, these types of things shown here, then you do have to have a special exception to maintain that information. So that's just kind of a side note that people need to be aware about. All right, our next area in this regulation is the rights of individuals. And the former privacy rule that was in place before this one had quite a few of these rights, but they've added two. And the two that they have added is the right to erasure and the right for data portability. And so just want to briefly focus on that, those two things. And basically the right to erase means that if the data has been provided to you and then the person does not want you to have their data any longer, and you don't have a legal obligation to maintain it or a contractual obligation to maintain it, then they have a right to ask you to erase that data. And you need to erase it from your databases, your backups, wherever that data is. And so people and organizations need to know how their data is being used, where it's located, how it's being backed up, those types of things. So that could very well be a challenge for some organizations. And then for data portability, basically it means that you should be able to transmit the information to another entity in the electronic format. And again, I revert back to HIPAA. I mean, HIPAA has its requirements from a digital data perspective, and it's very similar here, that it has to be in a format that can be interchangeable with other organizations. And so that's the definition of data portability. So just some examples of individual rights. The right for transparency, that basically means that a person has the right to know where their data is located, who has access to it, information about how it's being used, that type of thing, and it needs to be very clear in the communication to them. It can't be a lot of legalese out there, so that a normal person can understand where their data is and how it's being used. People have a right to be informed, again, about their data and where it's located. They have a right to be forgotten. That's the erasure right that they have, and then again the right for data portability. So now let's talk just a minute about the obligations of the data controller, and that's the organization that says how the data is going to be used, what information is collected, and that type of thing. So there's several key obligations here that that organization has. And the first one is that it needs to be protected by design and default. In other words, whatever you do, you need to design whatever system that data is being used in to be protected, and it needs to be secure. And that just relates to most of those on the call today, that we're very concerned about security, and we want to make sure we have those security requirements in place. We have to have agreements that these organizations, that our controllers have to have agreements with any other organizations that use the data. There has to be impact assessments completed on the data. In other words, very similar to an assessment, a risk assessment on the data, and this is from a privacy perspective. And in some cases, these organizations need to have data protection officers in place. You know, very similar to a security officer, your data protection officer needs to be able to have authority to make decisions on how data is protected. And then the last thing in this area is the breach reporting requirement. And that controller organization only has 72 hours to report any data breaches to their, it's called the Data Protection Authority, and that's just a identifier that the EU has put into place, that who needs to be reported to. So let's just talk just a little more about data protection by design and default, and this is the part that I think is very helpful from a security perspective, because a portion of GDPR, Article 25, and then also in Article 32, talks about a little more in-depth about the security of data. And it indicates that there are supposed to be appropriate technical and organizational measures provided from a security perspective. And these include encryption, ensuring the confidentiality, integrity, and availability of systems and services. This is probably sounding familiar to you. The restoration in a timely manner after an incident. So if you need to restore any of your systems after a disaster or an incident, that those measures need to be in place. And then continuous monitoring needs to be in place on this data. So very similar requirements to those items that most of us are already familiar, especially from a National Institute of Standards and Technology perspective. And so I believe that that helps support the security perspective here from GDPR. And so this applies to that data that is being processed that is for European citizens. All right, and that applies to the controller, the person that determines who has access and where the data resides. So as we look ahead and start planning, because this is going into effect here in a few weeks, a lot of people have already implemented many of the requirements for GDPR, and it takes all three areas in people, process, and technology in order to meet the requirements of this regulation. From a people's perspective, of course, you need to consider training and awareness. There may be staff that are unaware of the requirements. There may be staff that, you know, the shadow IT thing, we all know about that. We need to know where our data is and what data we have, and people may not be aware of the regulation and how it may affect the information that they have, and possibly the use of data that you as an organizational leader may not know that they have. And so definitely need to consider training and awareness for staff. You need to make sure that the information that you are getting about compliance is correct. And I can tell you that the information I'm providing you today is from both the International Privacy Association and as well as Microsoft, and those are the two places that I've done most of my research. And the second area, of course, is processes. And in order to become compliant with this regulation, processes do need to be updated, and privacy notices that organizations have out on, like on their websites or internally need to be updated to become compliant with this regulation. We need to consider, the framework and how we're going to implement best practices and processes within our organization. The last area, of course, is technology. Some technology, and I'd say a lot of technology is being updated. You just have to take a look at the technology that you have in place and see if this does apply to you, how you can use that technology to implement the requirements of this regulation. And I just referenced back to Microsoft, not that I'm promoting Microsoft, but they have done a lot in their Office 365 offering to be able to track data and to comply with the regulation. Other entities such as Amazon Web Services and vendors such as that have also done quite a bit. And so you just need to, if you think that you need to be in compliance with this regulation, that you need to take a look at what entities that you have in place and what organizations that you are using and see what they can do from a technology perspective to help you with the compliance of the regulation. So you might say, okay, what's next? I think I might need to be in compliance, but I'm not sure. And so there's a couple of places that you can go. There's a couple of quick assessment tools that you can take a look at. One is from Microsoft. The other one is actually from the European Union that has just a set of questions that you can take a look at. They're not very long. They're like 5 to 10 questions in each one. But basically, the questions that I would ask you if you think you need to be in compliance is, okay, do I know all the data that I have? Do I know where that data goes? Do I know who I'm exchanging data with? And can I demonstrate how that data is being protected and secured? And can I respond to someone that may want their data removed? And just, some general questions like that, I think that will help you if you think you need to be in compliance. And again, I'll go back and say it is up to your organization to decide whether or not you need to be in compliance. I'm just hopefully giving you some information today that will help you. So I would recommend doing one of these just real quick compliance type of questionnaires to see where you're at and what you need to do. And then from the risk management perspective, this is just like any other type of compliance. Most of us have to be in compliance with some type of framework. Many of us are following the National Institute of Standards and Technology, NIST framework. Some have to be in compliance with HIPAA, some the federal tax, So we just approach this again from a risk management perspective. And in my mind and in my experience here in risk management, there's just really 5 processes, and that's, first of all, you educate your leadership and your employees, and I think that then they will identify, what data may need to be looked at to see if you need to be in compliance. And then, of course, define and communicate your strategy of how you want to implement compliance, understand how you use your data and what needs to be done, identify the gaps there, implement controls, very similar to any other compliance type of risk management process. And then, of course, address your challenges around people, process, and technology. So, again, you just apply that risk management process to this compliance, and it should be very easy in the same process that you're familiar with. Now, there is one thing, or a couple of things I actually just want to touch on from a security perspective and the implementation of this particular regulation. You know, May 25th is just a few short weeks away. And so from the security perspective, we're going to begin to see scams. And we all just need to be aware of that. You know, you'll be receiving spam and more spam. We all know that about people thinking that your organization is out of compliance or that you're going to be fined. You know, all of those scam emails that go around anything like this type of new regulation. And so we just need to be aware of that. The other thing that's being considered right now is something that could affect some of us from a forensics or investigation perspective, and that is some modifications that they're contemplating doing to the WHOIS database, because the WHOIS database contains things like IP addresses and matching that IP addresses with people. And so they are contemplating removing that information from the WHOIS database, and so it could affect us in our forensics or investigation techniques. And so that is one of the negatives of this, and you just need to be aware that that information may not be available any longer after this goes into effect. And then, of course, look for other types of things like ambulance chasers, you know, people who are threatening, suing you, just all kinds of things like that. Just be aware that the scammers and people that are trying to take advantage of this regulation are out there and will be trying to take advantage of you as well as your users as this regulation goes into effect. And so that is the ending of my overview and presentation. And so now if we have any questions, I saw a few things that were popping up as I was going through here. So I'd be glad to maybe answer some questions that we might have. Jessica?
Lynn, thank you so much. That was a great presentation. We did get multiple questions that came in. First, I do want to address the question about attendees asking for slides. So the webinar recording will be located within a couple business days on the MS-ISAC EI-ISAC website. So keep an eye out for that, and you can certainly watch the recording on demand. We'll be working with you, Lynn, regarding sending out the slides if we're comfortable with that. So that answers a lot of questions that have come in. Now okay. I'll try to start at the top of the questions list just to go through those and you know, see if we can get some of them answered as much as we can. We have about 15, 20 minutes left. So I'll start with one question that came in. Firewall logs include source and destination IP numbers, but they are not linked to individuals directly. Could they be subject to this? That is one of the first questions that came in.
Yeah, okay, that's a great question. And so the answer to that question from all the research that I have done is that that they have determined, and they being the European Union, they have determined that IP address can be tracked back to an individual, and therefore they consider IP address as an individual identifier, and it is one of those items that is subject to GDPR.
Okay. Thank you so much. I think that some of these questions are similar. So one of the next questions that came in first was, how closely bound to this are sovereign tribes? Do we have the option of ignoring this, or are we likely to be forced to comply?
I'm sorry, could you repeat the very beginning of that question?
Sure. How closely bound to this are sovereign tribes?
So again, I think as I had indicated on the presentation, it's really up to your organization to determine your need for compliance. I am not an attorney, although I play attorney a lot. No, I am not an attorney, and so I can't help you with that determination. And I just don't know everybody's organization, and so you really need to make that determination on your own. So I really cannot answer that question. That just needs to be done by your own internal recommendation from your legal counsel.
Okay, thank you, Lynn. On that note, since a lot of questions do relate to this, should we pop back to that slide that has the survey link onto it to see, you know, if the attendees wish to take the survey, perhaps they can visit the link that you have there?
There you go. I believe it's the quick assessment. And I can tell you that Microsoft does have a lot of information on GDPR out at this particular address, and so it may be beneficial for you to go out there and take a look at that. But as well as the European Union, of course, they have a lot of information. And really, you know, the International Association of Privacy Professionals, Microsoft, and the European Union are really the only ones that I personally trust, just because of the nature of this, and interpretation, again, has to come from, you know, legal counsel, but those are the places that I recommend if people want any more information, you go to those sites. Perfect, thank you.
Your response might be similar to these two questions, but does GDPR compliance override mandated data retention policies is a question that we got a couple times.
Does it override mandated, I'm sorry, you have to repeat it for me because
that's okay.
I couldn't understand.
Mandated data retention policies?
Oh, okay. Again, you need to determine whether or not GDPR applies to you, and if it does, then you would need to incorporate the requirements of GDPR into your data retention policy. And so I think that, again, that has to be incorporated. That's one of those, one of the three things: people, process, technology. That's process. And you would have to determine, so yes, I need to be compliant, then I need to take a look at the requirements that GDPR has on data retention and adjust my requirements to those requirements.
Okay, excellent. The next question says, we found, they said, excellent presentation. We have found a lot of non-technical information in their research, not much at a technical level. Do you have any recommendation on where a good source of technical GDPR-related material can be found?
Sure. I would go back to the Microsoft site. They, again, have a lot of good technical information. And again, I don't want to promote a particular vendor here, but Microsoft has indeed done a lot of things from the Office 365 perspective that organizations do need to take a look at, because they have adjusted and they've put identifiers on to records and data, and you'll be able to track that data wherever it goes. And so I would encourage you to take a look at that information that they have.
Excellent. Thank you, Lynn. Next question is on about data breach reporting. Does GDPR define 72 hours from discovery of a breach?
So yes, the answer to that question is from the date and the time of discovery to the time of reporting. Now, reporting is to the regulator of the European Union. It's not notification out to individuals. It's reporting of the breach. So that is the 72-hour time frame.
Okay, thank you. Let's see, next question is about elections offices in Florida. So elections offices in Florida must comply with Florida sunshine laws. This basically means almost everything about someone's voter registration is public record, including overseas mailing addresses. Does GDPR conflict with this?
I would say no, because those are citizens of the U.S. and not citizens of Europe, if I'm understanding the question right. I mean, you have to be a citizen, and correct me if I'm wrong, in Florida you have to be, I would think, a citizen in order to vote. And the GDPR only applies to citizens of the European Union. And I guess I wouldn't think they would be voting.
Okay. Sounds good. Thank you.
Yeah.
This is an interesting question. Do you know if there will be any penalty after May 25th if we did not apply all of these regulations?
So the penalty is applied, but only to those that they investigate and say that you must pay a penalty. So again, it's very similar to HIPAA. If you are reported by a European citizen, they report you to the European Union that governs GDPR. And if that European citizen reports you and says, hey, my privacy is being violated by X organization, you need to take a look at them and see if they're in compliance with GDPR, then investigation is implemented, and the European Union Investigative Unit would investigate your organization and determine if you're in compliance, and if you're not, then they would determine how much penalty, how much you would have to pay for not having everything in place.
Okay, thank you. It seems like election topics are on people's minds today, so going back to voter registration, what if the voter is dual citizenship between the U.S. and the EU?
And yeah, that's a good question. And then, of course, I would say that their information would be covered by GDPR.
Okay, thank you. Similarly, when traveling abroad, if U.S. citizens are traveling to EU countries, does GDPR apply to the U.S. citizens' info when they're traveling abroad?
So GDPR only applies to European citizens, so not to U.S. citizens. But then again, the dual citizenship, I guess I apologize, I didn't consider that. If you have, dual citizenship, then if you are a citizen of the EU, then it would apply.
Okay, thank you. Just trying to read through all these questions here. Please feel free to continue to send in your questions. We'll get to as many as we can today. Let's see. I think we touched on this already. Are you able to, I just lost it. Are you able to point to tools for the data protection assessment impact?
So the two assessment tools that are up on the screen right now, I mean, that's where I would start. And then if you need an overall assessment, it's very similar to completing a risk assessment from a NIST perspective or an audit from your HIPAA perspective, then I would encourage you to have a third party do that. And there are third parties that are available to do different types of assessments, and GDPR is one of those.
Okay. There's a question about using wireless or free wireless. Would this apply in that instance?
So if you are recording IP address and I'm assuming that's what they're asking about, if you're recording like IP address or any type of identifiable information that was listed on the slide previously, then it would apply, whether it's wired or wireless. I'll go back up to that slide and we can take a look at, so databases, IP addresses, cookies, file shares, anything. You know, it doesn't matter if it's wired or wireless or public or private networks. If any of that data is being collected and stored, and it is from EU citizens, then GDPR should apply to it.
Okay, thank you. And someone also requested the slide that shows Article 25. I'm not sure if we've done that yet since we concluded.
Okay, let me scroll back down to find that one. And Article 32 is the other one that pertains to security. In fact, it's the one that describes the different areas, the 4 different areas that I spoke about that are not on this slide, and that is, and I'll repeat those in case that's what you're looking for. Those areas are encryption, so the data must be encrypted. Ensuring the confidentiality, integrity, and availability, the CIA, of systems and services where the data resides, and then, of course, restoration in the event of an incident or disaster, and continuous monitoring. So those are the 4 different areas that are really highlighted in Article 32, which is the primary article on security.
Okay, thank you. A couple more questions and then we'll wrap up. The question that came in just now, does desktop data need to be within GDPR compliance? Does it need to be scanned? I'm not sure if you already covered that.
So I think, again, doesn't matter where the data resides, whether it's on a desktop or a server or a log file, wherever, if it can be traced back to an EU citizen, or if it's EU citizen data, then it does apply from their perspective, yeah.
Okay, and what about, would GDPR apply to a training database where data removal would impact on the protections of an organization the user is affiliated with?
So a training database, and I'm assuming that they're thinking that they have European citizen data in it. Again, if it's data from European citizens now, if it's pretend data, then no, you know, but because a lot of times from a training perspective, we use made-up data, pretend data. But if it's real live data that's been collected from European citizens, then yes, it is under this compliance.
Okay, and one more question I think we have time for. It is unclear on what constitutes lawful processing beyond consent. For example, an EU company signs up for a web service in the U.S. that requires name, login, et cetera. Is that considered consent? Is this considered legitimate interest by the controller?
So if an organization has clearly identified that the information that they're collecting from the EU citizen is being used in a certain fashion, and they can opt in to that. In other words, that they're giving permission for their data to be used in that manner, and it is clear and understandable, then that covers that, you know, consent regulation, or that the option of one of the 6 options that you had. And I can scroll back to those options, but that's you have to have one of these 6 conditions in order to be compliant with the law, and consent is one of those. And so if it's clear, understandable, and they check a box that says I opt in to have my data do whatever's identified, then you should be good.
Okay. And one last question. I think this is a question that a couple of different attendees are having. If there's an investigation, does there need to be proof of harm to be penalized? What if this causes a small business to go out of business? Does the EU have any liability to the business?
I'm sorry, Jessica, about halfway through, you broke up a little bit, so if you could repeat the question, that would be great.
No problem. If there's an investigation, does there need to be proof of harm to be penalized? What if this causes a small business to go out of business? Does the EU have any liability to the business?
Wow, that's kind of a loaded question. I think that's yet to be seen, just because there hasn't been any enforcement yet of the law, and therefore there hasn't been any results, and so people don't know yet what the result is going to be for enforcement. And so I think that that's yet to be determined. There's been a lot of, you know, speculation about, you know, what would happen if this happened or that happened, and it could be, yes, the large penalties could put someone out of business. And I think that's really yet to be seen and determined by the courts and whomever. Again, you know, I talked about that earlier, about does this apply to us, because, you know, we live in the U.S. We're not, you know, we're not part of the European Union, and you have to determine, does this apply to your organization or not? And that, you know, we'll see how all of that pans out here in the coming months.
Okay, that is wonderful. Thank you so much for answering all those questions. I know we had a couple curveballs in there, so thank you again to Lynn Pizzini for presenting on today's Multi-State ISAC and Elections Infrastructure ISAC webinar. Thank you also to all of our attendees for joining today's event. A quick reminder that our next national webinar will be taking place next month in June of 2018, so please stay tuned for more information. As I mentioned earlier, there were a lot of requests for either the slide deck or the webinar recording. The webinar recording will be available as an archive on the Multi-State ISAC website within a couple business days of the live events. With that, thank you so much to Lynn again and to all of our attendees for joining us today, and we hope that everyone has a great day. Thank you very much.
Thank you.
Thank you, Lynn.